Good morning, everyone. Welcome to day 4 of the Different Strokes 2020 virtual stroke conference. For those of you who were with us yesterday, welcome back, and for new delegates, welcome to what is a very distinctly Scottish flavour to the day. We are this morning going to talk about legal matters and stroke, specifically around employment. My role today is to act as chair of the session and to monitor questions. I should have said at the start, my name is Alan Cowie. I'm the Director of Chest Heart Stroke Scotland. We have with us today Kate Wyatt. And for those of you who were with us last year in Perth, you'll remember Kate's session, which went down extremely well. Kate, you will know, is a partner with Lindsays, a Scottish law practice which has been around about for 200 years in Scotland. She specialises in employment law, as a member of the Employment Lawyers Association, and she works across a whole range of sectors: sport, social care, life sciences, higher education, and of course the charity and not-for-profit sector. On a personal note, Kate and her team have been an invaluable source of advice and guidance for my charity for a number of years. Kate is going to take us through her thoughts on returning to work and issues around employment, specifically when you're dealing with the consequences of a stroke. Now, before I hand over to Kate, my job during this is to make sure that the questions you ask are put to Kate and she will attempt to answer them. So if you can use your Q&A function at the bottom of your screen, any questions that you may have. I know we've had a couple of questions asked in advance, which we'll pick up at the end. Any questions you might have, please use your Q&A function and I will monitor that. The session, we've got up to an hour. Obviously, when we run out of questions, we will stop. So please take your time, think about what you want to ask, and I'll make sure we frame those and group them together where there's a particular theme emerging from them. So without any further ado, I'll hand you over to Kate.
Excellent. Thanks very much, Alan. I'm just going to share my slides. So hopefully they are now up on the screen. So as Alan says, I'm an employment law partner with Lindsays based in Scotland, and I'm going to be looking today at the employment law aspects of surviving stroke and returning to work. Now, what I'm saying is applicable not just to Scotland, but also to England and Wales from an employment law perspective. Employment law is a reserved matter, and therefore it's applicable not just in Scotland, but in England and Wales, because the law is the same across the two. Now, I'm afraid I'm not seeming to share my screen, so I'm just going to start a different share, and hopefully that will come up. Marvellous. So summarising then what we're going to be looking at, as you'll know from earlier discussions and presumably from experience, stroke does affect people of working age, so helping survivors address their ongoing issues is very much a workplace issue. And one of the most effective tools available is the obligation placed on employers in certain circumstances to make reasonable adjustments for employees with a disability. And I stress here that disability is a legal concept, and so when I talk about disability, it's for legal purposes and it doesn't go beyond that. And we'll look at what reasonable adjustments look like and how they can help in some detail. And I'll then go on to look at some practical tips for making reasonable adjustments work, because I think that's a very important way to make those reasonable adjustments effective and helpful as possible. And then I'll take a look at recruitment, followed by sources of support and a few thoughts about what lies ahead in these particularly turbulent times. So let's turn first of all to the definition of disability, which is set out in the Equality Act 2010, which is a physical or mental impairment which has a substantial and long-term adverse effect on the ability to carry out normal day-to-day activities. Disability, as I say, is a legal definition, and very often when I'm speaking to clients, they are not happy at being told that potentially they're disabled for legal purposes. But I think it's very important to be clear that it is that legal definition and it doesn't have to carry wider connotations. And as I say, some of my clients really don't feel disabled and don't want to be classified as such, but the importance of the legal definition is that it brings with it quite a lot of protections. So looking then at those elements which are likely to be applicable to those who've suffered a stroke or the results of a stroke, an impairment obviously can include the after effects of a stroke. Substantial simply means that it is more than minor or trivial. So that could include, for example, that it takes longer to do things. Long term, in the context of the legal definition, means that it has lasted or is likely to last for at least 12 months. And it's important to stress that the protections here of the Equality Act can apply to people who've had a disability in the past, if that adverse effect is likely to recur. So just because you're currently well doesn't necessarily mean you don't fall within that legal definition. Affecting the ability to carry out normal day-to-day activities, those normal day-to-day activities would be what you'd usually think of, so things like shopping, reading, walking, travelling, and general work-related activities, such as using a computer or verbal interaction. There doesn't need to be a substantial adverse effect on very specific work-related activities relating to specific work types. It's normal day-to-day activities. The importance of falling within this legal definition is that a person who is disabled for legal purposes is entitled not to be discriminated against, whether directly or indirectly, and specific to disability, they're entitled not to be treated less favourably because of something arising in consequence of disability. And that would include, for example, disciplinary action or dismissal because of higher than usual absence related to disability, unless that treatment can be objectively justified. And that again is a very helpful protection. There's also protection against harassment or victimisation. So for example, if you've raised a concern about disability discrimination, you're protected against harassment because of doing that. But the key tool, I think, for those returning to work is the obligation to make reasonable adjustments. And so we'll look at that in a bit more detail. Now, the requirement to make reasonable adjustments is set out in Section 20 of the Equality Act, and I've set it out on the screen. It applies where a provision, criterion, or practice applied in this context by an employer places a disabled person at a substantial disadvantage in comparison with someone who is not disabled. Where this happens, an employer must take such steps as are reasonable to avoid that disadvantage. There are similar requirements where a physical feature of an employer's premises places a disabled person at a substantial disadvantage, or where, but for the provision of an auxiliary aid by an employer, such a person will be placed at a substantial disadvantage. Now, the importance of the requirement to make reasonable adjustments is that it is a positive obligation to make beneficial changes. It's not just an obligation to avoid discrimination or to treat people with disabilities the same as those without. In effect, it requires employers to create a level playing field by treating people with disability more favourably in order to counteract that disadvantage. This obligation to make reasonable adjustments applies to those who fall within the legal definition of disability. But the Westminster Government has identified in a policy paper from June of last year called Health is Everyone's Business that there is scope to extend a similar obligation in respect of employees or others who don't meet the definition of disability for legal purposes, but who have still suffered from a health condition which affects their work. And they have therefore proposed a parallel right which would not replace or change the obligation to make reasonable adjustments as set out in the Equality Act, but would be a parallel entitlement to request workplace modifications on health grounds when they are returning from sickness absence of 4 weeks or more. The government went out to consultation on that proposal of the right to request workplace modifications, and that consultation closed in October of last year. Obviously, there's been a lot going on between Brexit and coronavirus, so we don't have any date yet, but I think it's a good indication of the direction of travel, which is to improve the ability of people with health conditions to participate in the workplace by making it easier for them to obtain necessary modifications to their workplace. So that's how reasonable adjustments work. What I want to take a look at now is how they can be made to work as well as possible in practice. So getting them across the line with your employer, if you like. First of all, there's a concept or a belief on some employees' part that they need somehow to prove their disability, and that a medical report is the only way to do that. This is not really the end of the story. Employers do have to properly inform themselves about an employee's medical condition, and medical OH and GP reports are really important to that end, and any employer who hasn't obtained at least an OH report is not really likely to fully understand the extent of any disadvantage, and therefore any steps that they may need to take to resolve them. But even if an employer has a medical report which says either this employee does have a disability or this employee doesn't, they have to reach their own decision and not simply rely on that medical evidence. So it's very much a decision and a conclusion that an employer has to reach based on their understanding of what that particular individual is experiencing. So assuming then that the definition is accepted by an employer, how to increase your chances of having a reasonable adjustment agreed. And I think it's really helpful to take a collaborative approach here and to think very carefully about what will work and how it will work, and then try to agree that with your employer, because that can help take away some of the fear factor that some particularly small employers have when reasonable adjustments are proposed. And I think it's really useful to approach this in a very similar way to the way flexible working requests are approached. In effect, to make a proposal and then present it to your employer. And the first thing is to think the adjustments through. And so what will the impact of the adjustments that you're proposing be on other staff? If there's going to be any negative impact, how can that be managed? Think about the availability of support. And so beyond the simple fact that if an adjustment is reasonable, the employer should meet the cost of it, it may be that you can add additional support to that, which will be at no cost to the employer. So for example, additional support from access to work, or support provided by organisations such as CHSS, or from different strokes. And the other thing is, in your proposal, think about the cost. And very often employers, and again, particularly small employers in my experience, think that any adjustment is likely to involve significant costs or administrative burden. And often the costs of an adjustment are actually very low, if not zero, and it's certainly outweighed by the costs that will be involved in recruiting or training. Now, that said, it is not the employee who is obliged to make all the running. The employer must itself consider reasonable adjustments, even if none are suggested by an employer where that obligation arises. So employers must be positive and proactive. And I think I'd like to echo something that emerged from Austin's talk earlier in the week, which is that it's not the case that if adjustments have been made for a previous employee who suffered a stroke, the same adjustments will necessarily be appropriate for another employee. It is not a one-size-fits-all approach, and your employer should be looking at your particular circumstances, and they should be looking at what is going to work for you. And that may not be one adjustment, it may be a whole package of reasonable adjustments which work together. I've set out on the screen some examples of reasonable adjustments, and so that can include providing equipment to help redress disadvantage, making amendments to policies and procedures. And one of the things that very often comes up here is adjusting triggers for action related to sickness absence. So many employers will say, if you've had more than a certain number of sickness absences within a certain period, then we will move into an absence management process. Now, clearly, if you are going through a rehabilitation process, it is likely that you will, at least in the initial stages, have greater than usual sickness absence. And therefore, it may be a reasonable adjustment for your employer to extend the triggers before which there will be any formal disciplinary or other action. There may need to be adjustments to premises to make sure that access is easier. Or there may need to be adjustments to working hours. So, for example, either staggered working hours, reduced working hours, or flexible working hours as a reasonable adjustment to allow you to cope with any increased fatigue. Another way of looking at it as well is to work with your GP, and so use the fit note process. You'll probably know that on a fit note there's scope for a GP to say that somebody may be fit to work and to make specific recommendations about what adjustments may be helpful to get somebody back to work. And again, that's a useful basis from which to start a discussion with your employer. But also, when you're considering what reasonable adjustments may help, take a look at the Equality and Human Rights Commission Code, because that contains a number of really helpful examples. And I'm just going to read 3 of them to you now from the Equality and Human Rights Commission Code. The first one is, an employer allows a disabled person who has recently developed a condition to have more time off work than will be allowed to non-disabled workers to enable them to have rehabilitation. The second is, all workers are trained in the use of a particular machine, but an employer provides slightly longer or different training for an employee with restricted hand or arm movements, or training in additional software for a visually impaired person so they can use a computer with speech output. And the third one related specifically to stroke. A disabled person returns to work after a 6-month period of absence due to a stroke. Their employer pays for them to see a work mentor and allows time off to see the mentor to help with their loss of confidence following the onset of their disability. And I think that last example is really helpful, because it highlights that reasonable adjustments don't necessarily need to be what many employers will automatically think they are, which is the provision of equipment, changing your premises, etc. They can be something far less concrete. Another really useful thing to do is to get engaged in the kind of support groups that Austin was talking about, or the kind of support groups that are available through CHSS, and find out what's helped others, because those kinds of things are really useful to you when you're forming your proposal for the employer. Also, when you're creating your proposal for the employer, it's useful to think about what amounts to reasonable. And from a legal perspective, when we're thinking about what amounts to reasonable for an employer to do, we will be asking, would this adjustment be effective in preventing the substantial disadvantage? Now, it doesn't need to be a dead cert. It doesn't need to be completely obvious that this adjustment will prevent the disadvantage. If it has a good chance, or even a 50-50 chance of preventing that disadvantage, it may be reasonable to put it into place. We'll be asking, is it practicable? Can the employer actually do it? What's the cost going to be? Is there going to be any significant disruption? And if so, can that be managed in a pragmatic way? Relevant as well is the employer's financial and other resources. So it's likely to be more reasonable for a large employer to take greater steps than it is for a smaller employer with fewer resources. But also, it's important to look at what kind of external financial and other support is available to those employers in deciding whether it's reasonable for that adjustment to be made. Coming back again to the Westminster Government's policy paper, Health is Everyone's Business, the government is looking to improve the support, resources and advice which is available to small and medium-sized organisations in particular, so that it can improve the support available to them, but also their confidence in making reasonable adjustments to working environment for employees with disability. And finally, don't forget to offer a trial period to your employer, because again, that can really help cope with the fear factor for employers that they are suddenly going to be required to carry out an adjustment which really isn't working for them. If you can agree a trial period, and that trial period can involve reviewing and adjusting that reasonable adjustment so that it works for both, it can be really, really helpful. Now, where an obligation arises to make reasonable adjustments, it should not be used by an employer as an excuse to dismiss or disadvantage. So, for example, not to promote an employee because it needs them to make some kind of costly reasonable adjustment. If it is, then that's potentially actionable. Now, if you believe that a reasonable adjustment should have been made to your working environment and it hasn't, I would recommend, if you haven't already done so, that you go through that process of thinking about what the reasonable adjustments you think will help will look like, making that proposal to your employer. And if that is not progressed, you should raise a grievance. And again, if that doesn't resolve the problem, you have the option of bringing a claim to an employment tribunal for a failure to make reasonable adjustments while you're still in employment. You don't have to resign in order to have an active claim. But what I do want to stress is that this obligation, this very powerful obligation to make reasonable adjustments, will only arise where an employer is aware or should be aware that an employee has a disability. Now, I'm conscious that in most circumstances, employers will be aware of disability, but if for any reason you think they might not be full aware of your disability or the extent of disadvantage that you suffer, it does help if you're open, because then the obligation will arise. Right. Sorry, I'm not seeming to be moving on here. I seem to have frozen up. My apologies. Alan, I don't know if you're able to move the slides on. Right.
There you go.
That's it. Brilliant. So looking now at recruitment and kicking off first of all with pre-employment health questions. Pre-employment health questions includes questions about levels of sickness absence, and they will be prohibited in a pre-employment, so recruitment context, except in very limited circumstances. And the first is after somebody has been shortlisted for or offered a role. But bear in mind, if you get to that stage and you've been shortlisted or offered a role, you then disclose your disability or levels of sickness absence, and the offer is withdrawn, it may be discriminatory, especially if the employer hasn't taken the time to consider what reasonable adjustments it could put in place to help prevent levels of absence or any problems related to the disability. Questions can be asked to establish whether reasonable adjustments are required for the recruitment process. So, for example, access to an interview space, or alternatively, any special requirements relating to practical assessments. Questions can also be asked to establish whether an applicant can carry out a function which is intrinsic to the role. So, for example, if you're recruiting, and this is an Equality and Human Rights Commission example, if you're recruiting for a scaffolder, it's perfectly reasonable to ask whether they can work at heights. It's perfectly reasonable to ask if they are relatively fit and active. But if you're recruiting for an office role, there is no need for somebody to be able to work at heights, and there is arguably no need for them to be particularly fit and active. And therefore, that is not a question intrinsic to the role, and it should not be being asked. Questions can also be asked to monitor diversity, but if you're asked to provide diversity information, that should be kept separate to your application, and wherever possible shouldn't be disclosed to those who are responsible for the appointment process, so that it doesn't colour their decisions. Permitted positive action, that's also possibly the subject of pre-employment health questions. So, for example, to establish if a guaranteed interview should be offered, or where a role actually requires somebody with a specific disability to fill it. Now, this duty to make reasonable adjustments that we've just looked at in quite some detail does also apply in recruitment, and can again be a very powerful tool, but it only applies when the employer is aware or should be aware that somebody has a disability. So people who apply are protected and entitled to reasonable adjustments where appropriate, as are those who tell an employer that they're thinking of applying for a particular role. And it can seem a bit counterintuitive to suggest that you are very open about disability when applying for a role, but from my experience, good employers are open to making adjustments for able and committed applicants to enable them to overcome disadvantage. The Equality and Human Rights Commission also does make it clear in the code that when an employee, or an applicant rather, voluntarily discloses a disability, they can go on to ask further questions about that disability, but they should only be related to a function intrinsic to the role and not irrelevant. So if you were to disclose disadvantage related to a stroke and you're applying for a sedentary office role, then you really shouldn't be the subject of further questions about your level of fitness or activity unless they relate to something specific about that role. Now, the obligation to make reasonable adjustments in the recruitment context is not anticipatory. So, for example, you shouldn't expect a recruiting employer already to have information available in all formats, but they should respond promptly once you've clarified that you may need some adjustments for the interview process, etc. When I'm advising employers who are going through a recruitment process, I always recommend that they take great care over job and person specifications to ensure that they are not asking for irrelevant and potentially discriminatory criteria. So that comes back to the active and energetic requirement, for example. Does somebody doing a sedentary office job really need to be active and energetic? And the answer is no. So is it really required? And so when you are going through a recruitment process, I think it can be really helpful to take a good close look at the job and person specification and keep an eye on that throughout the recruitment process. So is the interviewer focusing on the job and person specification, or are they veering away into asking questions which are really not focused on that and are irrelevant to that? I've set out on the screen a couple of examples of reasonable adjustments in recruitment. So, for example, providing information about the role in an accessible format, arranging for interview in an accessible environment, or allowing extra time to complete an assessment. When you do get a job offer, the terms that are offered to you should not be less favourable because of your disability in terms of pay, seniority, etc., than would have been offered to somebody without that disability. So just keep an eye on that as well. So there I put up a number of sources of support. The Equality and Human Rights Commission and its Code of Practice are really helpful. I think the examples given of reasonable adjustments can be a real useful guide, as can discussing it with others, but take a look at those options as set out in the Equality and Human Rights Commission guide. ACAS has also produced guidance which is very helpful and available through that link, and always worth taking a look at access to work in terms of what may be available above and beyond what your employer may be able to offer. So let's take a look now at what lies ahead. And I think we do need to keep pushing towards a focus on raising awareness of the role of reasonable adjustments. There is a perceived lack of awareness of the support that there is out there for employers, and there is often a misguided belief on the part of employers that changes, as I've said, will be prohibitively expensive. And again, as I've said, this is often incorrect in comparison with the costs of recruiting or retraining somebody else. And this is a big focus of the policy paper, Health is Everyone's Business, that I've already referred to. Now, the Good Work plan has resulted in many of its suggestions being embodied in an employment bill of 2019, and that includes the requirement to advertise all jobs as flexible, and it's been created as a duty on employers to assess whether a job can be done flexibly, and if so, to advertise it as such, unless there's a good reason not to. As I say, this is in the 2019 employment bill. We don't have a timescale. Again, there's been a lot going on between Brexit and coronavirus, but the hope is that this will become law in a reasonable period of time. The focus, again, has to be on a great awareness of sources of support, and particularly for small and medium-sized businesses, for whom it may be both a little bit more unnerving and a little bit more difficult financially speaking. So it's useful that the Westminster government is looking to increase awareness and sources of support, particularly for the smaller employer. There was floated the suggestion that the reasonable adjustments role, or the role for reasonable adjustments in helping employees with disabilities to stay in work, was made easier to implement. At the moment, it's very much the boot's on the employer's foot because the obligation is with them. But what was suggested was that we formalise the right to request reasonable adjustments in the same way as there's a formalised right to request flexible working. And this fits in, I think, as well with the suggested right to request workplace modifications, which again has been floated by the government policy paper. Brexit, when we were doing this presentation or when this conference was taking place in May 2019, there were some interesting developments arising as a result of Brexit in terms of what businesses were doing to combat likely staffing shortages when freedom of movement ended. And what some employers, some forward-thinking employers were doing was to say, we are going to target a particular section of the workforce so that we can make our environment as attractive as possible to them and bring them in greater numbers to fill any staffing shortages caused by Brexit. So for example, Travelodge were trying to beef up their family-friendly policies to ensure that they were attracting more working parents back in to the environment. There was options there, I think, or there was certainly great scope there for businesses to do a very similar thing in terms of people with disabilities, so improving their policies, improving their environment for those with disabilities. We're obviously in a very different world now, post-coronavirus, with a lot of people having been made redundant, but I think there are still opportunities there to encourage that kind of approach and that kind of focus on filling staffing shortages in certain areas. I haven't spoken about coronavirus. I think we've all lived and breathed it for the last 6 months, and I don't want to go into it in any great detail, though I am happy to take any questions on it. But what I would say is that if you have particular health concerns, do discuss them with your employer, check their risk assessment and their coronavirus policies and procedures. One very useful approach is to take a look at the Scottish Government's individual risk assessment, which will give you an understanding of your own personal risk and again form the basis for you to perhaps have some discussions with your employer. One of the side effects of coronavirus has been a significant increase in home working, and I think this can be a very good thing in the sense that it's going to be much harder for employers to say that home working is not possible in the future, because it has worked, it's had to work, and many employees have been working from home very effectively. But home working does also have its downsides, including a risk of isolation, but also a risk, I think, for people with disabilities of having a workplace at home which is much less well adapted than their office-based environment. And in the first few months of enforced home working, it may well have been reasonable that employers weren't able to make appropriate adjustments to a home working environment. But as we move into much more long-term home working, and the Scottish Government, I think, is managing expectations further and further down the line in terms of continued home working, I think it's important for employers to get clued up to the fact that they have equivalent obligations to take appropriate steps to ensure the health and safety of their workforce wherever they are, whether they're working in the office or whether they're working at home. So if you do need some help at home, if you do need some adjustments to be made at home, you may find that it's helpful to have a specific workplace environment assessment at home, and also to engage with your employer over what extra support you may need. That's all I was going to say. Alan, I see we've got 4 questions. Do you want to run them by me?
Yeah, of course. You want to unshare your screen? If that's a word. Let
me just... There we go. That's it.
Thank you, Kate. Thanks for a great presentation. I think some brilliant legal insights and employment issues and real practical advice that I hope people found extremely helpful. We have a number of questions, and I'll go into the Q&A in a wee minute. There was a number of questions asked in advance, and I think you might have covered it, Kate, but they were all focused around recourse to action if a person feels that their employer hasn't responded with respect to support and reasonable adjustments. Just wonder if there's anything else that you wanted to add on that.
Yeah, I mean, I think one of those things that it's really helpful to say is that I think a collaborative approach generally will bear more fruit. If you are looking for an ongoing relationship with an employer, the more collaborative you can be, the better. Now, that said, if your employer is not aware of its obligations, it can be quite a difficult conversation to have. So I think taking some advice, whether that be from organisations such as CHSS or Different Strokes, the CAB, or just generally from the government websites, can be really helpful so that you understand what your rights are and that you can then go and have that discussion with your employer. So firstly, know what you're entitled to and understand what you can ask for, and don't be afraid to ask. If you're not getting anywhere, I think raising a grievance can be really helpful. It can also help protect your entitlement to compensation if you do have to go further down the line. If you still don't get anywhere after raising a grievance, then legal action is a possibility. Bear in mind that you do have a limited period of time to bring a claim, so don't get sidetracked by a protracted grievance process. I think this comes back again to making sure you've taken some legal advice. It doesn't have to be legal advice you pay for. You can certainly get some very good and practical legal advice from the CAB. So I would say take a collaborative approach. If that doesn't work, raise a grievance. And if that doesn't work, then look at whether legal action while you're still in employment for a failure to make reasonable adjustments may be appropriate, but be aware of timelines.
Thank you. Just as you were speaking, Kate, another question came up related to this, and I couldn't see the person's name, so apologies, but they wondered whether or not these adjustments would relate to someone who works freelance and I assume self-employed.
Mm-hmm. So the protections against discrimination apply to employees and workers. They're both categories of employment relationship. It can in some circumstances apply to the self-employed, but that's much more limited. So I think, again, take advice on your specific circumstances. But even if this obligation, this specific legal obligation doesn't apply, have that discussion. It's about making sure we're trying to make employers better employers. And so even if you don't fall within that legal definition of disability, even if you are not entitled to the benefit of reasonable adjustments from a legal perspective, ask. It's definitely worth asking. The final category of people to mention is volunteers. I'm afraid volunteers are not protected against discrimination. It seems a very odd thing to have to say, but I'm afraid that is the way it is.
Okay, thank you, Kate. I'll move on to the questions in our Q&A box. Dara asks if employment law you're talking about applies in Northern Ireland.
Northern Irish law is different. It's subtly different. You still have the Disability Discrimination Act. I think it's 1995, but I'd have to check. I think it's one of those things. It's very similar, but it's not sufficiently similar that it's the same. So I would take local legal advice. You are protected against disability discrimination in a similar way, but there are differences of emphasis and the law itself is different.
Thank you. Louise asks, what protection is there for people with disability applying for new jobs? And how easy is it to show a potential employer has discriminated on the basis of disability?
So I think this comes back to the bar on pre-employment health questions. If you believe an employer has been wrongly asking pre-employment health questions, then I would get in touch with the Equality and Human Rights Commission. If you believe an employer has failed to make reasonable adjustments in the recruitment process, or if they have, for example, withdrawn an offer when you disclose a disability, both of those are potentially actionable by a claim to an employment tribunal. So again, I would take legal advice, go and have a chat to your local CAB. I mean, I can imagine that it is absolutely heartbreaking to apply for a role that you know you can do and that you would be well suited to, and have an employer either not make the adjustments that would make it work for you or to withdraw an offer. And if that has happened, as I say, there is recourse there for you in terms of taking forward a failure to ask pre-employment health questions appropriately or a failure to make reasonable adjustments.
Sarah asks, she says that she has aphasia and can't speak and formulate answers on the spot. Is it reasonable to ask a potential employer for interview questions in advance?
Well, I think that's a very interesting one, isn't it? I think you might not get them to agree to providing the interview questions in advance, but what I would do is I would ask, and if they say no, I would then suggest something different. So, for example, would they give you more time? So when you turn up for the interview, would they provide you with the interview questions then and there and give you half an hour extra? Or if you need more time extra, extra time. So it's about perhaps not being completely rigid, but opening up that dialogue and try to find something that's acceptable to you and something that's acceptable to the employer. But certainly, I think that is something where a reasonable adjustment would make a huge difference, and it would certainly be appropriate for some form of adjustment to be made.
Thanks, Kate. A question from Janice. Can an employer force an employee to undertake further education to obtain further qualifications? My husband has been told he needs to do this, but he feels it's not necessary for him as he wants to retire in 3 years' time, and he also finds it hard to retain new information due to memory problems post-stroke.
Okay, I think that's a very good question, and I think the way it's first asked doesn't really bring in the disability element of it. I think that given the memory problems which are associated with stroke, I think it's certainly worth having a discussion where you've situated it within the reasonable adjustment context, because it seems to me what may be causing the problem here is that the employer doesn't understand why your husband is not wanting to undertake the further qualifications and why he doesn't feel they're appropriate. I would open that discussion with them, having made sure they understand the reasoning behind your husband's reluctance to take on that further educational qualification. And it may well be that it's a reasonable adjustment not to require him to take those additional training courses. I think it's worth saying that the question of whether or not an adjustment is reasonable is decided in the final analysis by an employment tribunal, objectively speaking. So when you are looking at what would be a reasonable adjustment, it's quite important or very helpful, I think, to go through that process of understanding what the disadvantage is, what can be done to redress that disadvantage, and why it's reasonable from the perspective of your employer. And if you've gone through that process and you do then wind up in tribunal, it's much easier for a tribunal to look at it and say, objectively speaking, that adjustment, not requiring you to go through further educational qualifications, would have been reasonable for the employer to do.
Thank you, Kate. We are at the end of questions now, and unless anyone wants to ask a final question. Oh, and you had prompt one. This is from Deirdre. I was working over 124 hours a fortnight. I collapsed on the floor. My daughter called the ambulance. I had a stroke. My husband sent the SSP over 8 months, but in April I received a P45, no sickness policies. I had a grievance, but they did not pay overtime. Sorry, I'm reading this out. I had a grievance, but it did not pay overtime over 2,000. They paid me, but Deirdre, I'm unsure of your question, and this is it possible for you to help me formulate the question? I can't really pick it out from what you've said.
Austin, I'm wondering whether what Deirdre is saying is that she was dismissed without any process or procedure, and generally, assuming she has over 2 years service, and even if not, if it's related to her disability, a dismissal without any process, without an employer taking medical advice to understand prognosis, likely return, etc., is unlikely to be fair and is likely to be discriminatory. But I think it's important to take some legal advice there, and also to bear in mind time limits. If you have not been paid sums that you're entitled to, in principle that's an unlawful deduction from wages, or potentially as well a breach of contract, and that also is actionable. Time limits apply, but they're a little bit more generous in terms of breach of contract claims, so 5 years in Scotland, 6 years in England and Wales. So I think that kind of unpicks the two elements, Deirdre. If I've missed anything, or if that's not really what you were asking, please do provide more information.
Yeah, I hope that answers it, Deirdre. I think obviously taking legal advice is going to be an important step in that. If there are no other questions, it just falls on me to thank Kate for a really great presentation, some really great insights and hopefully practical advice that you'll take forward in your individual situations. And what I got from that was a sense that the law is with you, and the need to work collaboratively with your employer, potential employers, to seek resolution. So I hope you found that helpful. A huge thanks for your time today, Kate, as always. And a huge thanks to everyone who's joined us this morning, all 34 of you. I hope you found that informative, and I hope you stay with us this afternoon. So thank you.
Thanks very much.